Case flow management. Perhaps the first time we heard the reference to justice delayed is justice denied was in the Magna Carta in 1215. Much more recently, of course, there has been a lot of discussion over the years about court delay. And in fact, in the formative years of the National Center for State Courts in the 70s, the center undertook a very broad study of the delay of cases in the trial courts, urban trial courts across the United States. One of the things that was discovered is that we had this culture that the pace of litigation should be controlled by the attorneys, the litigants, the parties. And we began to see a change in the belief that that pace of litigation should be controlled by the judges. So what have we learned in all these years? Well, one thing that we have learned is in order to change that culture from allowing the attorneys to control the pace of litigation to the courts controlling the pace of litigation, we had to work together. The judiciary, the bar, other stakeholders had to work together to move that culture. One of the things that happened over this time, and one of the questions that is always asked is, well, what is the proper pace of litigation? And so now we have model time standards that have been developed by just such a collaboration of stakeholders. And those model time standards basically give us guidelines by case types as to what the proper pace, how long it should take from filing to disposition by various case types. In local courts, in order to change a culture from one of the attorneys controlling the pace of litigation to one of the courts controlling the pace of litigation, we also have to form that stakeholder group to move this culture. And among the things we've learned in addition to that is that early and continuous control of these cases is necessary. Intervention in the first part would be, upon filing, is to classify by type of case and put it in these various tracks according to the different time standards. And we have called this differentiated case management. More recently, Doctors Clark and Flango have suggested that courts ought to do some additional triage of cases, that courts should perhaps work so that they have professional expertise to help litigants decide whether the court is the proper place for them to have their case decided, whether there are alternatives, whether there are community services, or whether in fact they do prefer to file their case in court. So that's a triage in that sense is something beyond case differentiated case management. Among other things that we've learned is that if we're going to proactively manage cases, we, court staff and judges, have to be able to monitor these cases from the time of filing through its various procedural requirements, filings of documents, hearings, scheduling of hearings, etc. And frequently, technology is a tool that can help us with that monitoring and workflow. In addition, technology can help us, since it's such a document-laden process, either through e-filing or the more laborious scanning, nevertheless, to have these documents in a document management system accessible for all. It reduces a significant amount of time. One of the other things that we'd like to conclude in this brief video this morning about case flow management and important concepts is the thought of continuances. It is important that we develop in our local legal culture the idea that when a case is scheduled, when a hearing is scheduled, that it is likely to go to trial, as opposed to unlikely to go to hearing or trial. When we develop the belief in the legal community that the case is scheduled but not likely to go to trial, then the likelihood is that attorneys will come not prepared for the hearing, that their litigants will not be with them, that witnesses will not be there because the attorneys believe that the case will not go forward. So it's important in our scheduling process and habits to schedule the right number of cases to ensure that these cases do go forward as scheduled, to change that culture again to one in believing my case is scheduled and I know it's going to go forward. So I suppose the most important thing that we can say is it's this change of culture, to understand that we have time guidelines for various types of cases as to how fast they should proceed from filing to disposition without unreasonable delay, and that we get everybody, the attorneys, the litigants, the stakeholders, the judges, the court personnel, in believing in that culture. If we've learned anything about case flow management, we've learned that cases do not flow through the courts. Courts must manage them.